If you've gotten this far in life and you don't know who the state is, buckle up.
Yeah, we'll stick a box underneath the bottom chair then. All right. Left. Left.
Left.
Left. Oh my God, it's already starting. Okay. Hi, everybody, and welcome once again to my show. I don't think they can see me. We'll put another box under the bottom chair, you moron. Hi, everybody.
And
What a show we've got lined up for you tonight.
we've got everything.
Now, before we head into this masterpiece of sovereign logic, make sure you like, subscribe, comment, and share. It's free, and it keeps the algorithm happier than a Sovcit discovering a new website. Now, let's visit our friend Sovereign Haynes in Texas, charged with expired registration and failure to maintain financial responsibility, which is code for no insurance. Two very ordinary Texas misdemeanors. He took those to trial, and he lost on both of them. And now he's back, appealing the verdict because he says the court has no jurisdiction. Apparently, he expected the state of Texas to personally appear like some contestant on The Voice. So this time, we're looking at the arraignment, his pretrial, and now his motion for a new trial after already being found guilty. Let's roll.
So we have the defendant, Vincent Luis Haynes. He's facing 2 charges, expired registration and failure to maintain financial responsibility. And in July, he filed a notice of abatement. And a motion to dismiss. Mr. Haynes, can you please, there you are, Mr. Haynes, there, unmuted. All right. So, Mr. Haynes, do you wish to summarize your motions at this time?
Yes.
Go ahead, sir.
In my notice of abatement, I am asking for the court to show that it can uphold the Constitution in reference to Article 6. I am basically stating that I am a natural person. You know, I'm in the court even currently right now with my Lord and Savior Jesus Christ, and the notice of abatement just goes to the heart of the matter as to the jurisdiction, both subject matter and personal jurisdiction, and to make sure that these proceedings are done to assure equity and fairness. I realize that this court may not provide a remedy for me, and so at that point, I'm asking for adjunctive relief if that would be appropriate.
Mr. Haynes, you're using terms that are civil terms. This is a criminal court. These are Class C criminal charges, which carry a fine as their punishment. This is not a court that gives a remedy to a defendant. You are charged with a citation. You are charged with a crime based on the actions of a police officer.
Who did I offend?
No, sir, hang on. I'm not done.
Okay.
So I want to make sure you understand you're using civil terms. The rules that apply in this court are the Texas rules of criminal procedure. And those are the rules that dictate how the hearings and trials will proceed. And it is the Texas laws which grant this court jurisdiction in these matters. I'll make sure you understand that. If you wish to continue to summarize anything, you may, but I want to make sure you understand you're using civil terms. This is a criminal court.
Okay. Even in a criminal matter, ma'am, I still have a right to face my accuser. Again, that's what the abatement was about. And who accuses?
Sir, hang on a second. You haven't gotten to that point yet because this is a first setting, and if you plead not guilty, there will be a trial. But as you've seen here tonight, many people plead no contest or are guilty. Therefore, there is an opportunity to hear and have all the accusations presented in court. You just have not gotten there yet.
Yeah, I don't understand that.
Okay. Well, Mr. Bishop, does the state have any response to the abatement motion?
Yes, and I'm just seeing this motion for the first time tonight, but it appears he says that the court lacks subject matter jurisdiction over this ticket, and therefore the action should be abated. I'm summarizing that, and the state's response would be that this court has jurisdiction to hear citations for traffic violations and Class C misdemeanors in the city of Dalworthington Gardens. And so it appears these tickets were all alleged to have occurred in Dalworthington Gardens, and therefore we respectfully request that the defendant's motion be denied.
Your motion for abatement or notice of abatement,
It's a notice.
your notice of abatement is filed, sir, but there's no action that this court is going to take at this time. And you have filed a motion to dismiss. Before we go into that, sir, there's a couple of things that I want to make sure to put on the record. You've been here in the Zoom courtroom tonight. At the start of court, I went over rights and options that defendants have. Did you hear those rights and options, sir?
I heard the rights and options that's pertaining to those particular defendants, yes.
Yeah, that was to every defendant set here tonight. Do you have any questions about those rights and options?
I mean, I don't understand them pertaining to me.
Well, they pertain to you because you have received a citation and you're charged with this offense. You may not agree with it and you may not like it, but they apply to you because you were in the city of Dalworthington Gardens and received these citations. So that's how they apply to you. Now, as I warned everyone at the start of court, you have the right to be represented by an attorney. And if you wish to have time to consult with an attorney, please let me know and I will give you a pass until next month's docket. Otherwise, if you do not have an attorney hired to represent you, you will be held to the same standard as if you were an attorney. So at this time, sir, do you wish to represent yourself or do you wish to have a continuance to consult with an attorney?
I'll represent myself.
Okay. All right. All right. And if you do not have any other questions about the rights or options that I went over at this time, we can proceed now to the motion to dismiss. If you wish to present that at this time, you may summarize your argument for the court at this time.
The motion to dismiss comes from the fact that I put a notice of abatement in, and I never got a response from my notice of abatement. Just basically asking the court, for its jurisdiction. You're explaining how your jurisdiction kicks in, but it's not relating to what I'm saying. I don't go by misnomers, and I seek, the honorable court to apply fairness, and equity. This court does not state whether or not this is a court of equity. You're telling me right now that this is a criminal court. You're saying that this is a criminal case, and you're not really presenting a crime that I see that would be tantamount to criminal proceedings. But again, everything is laid out in a motion to dismiss, and I feel that it is warranted because the court does lack subject matter and personal jurisdiction in this hearing.
Response from the state, Mr. Bishop?
Motion to dismiss should be overruled, Your Honor, or denied. State has jurisdiction here. This individual was using the roads or highways of the state of Texas. And by doing so, as is driving being a privilege, not a right, was bound by the laws of the state of Texas when driving. The allegation is he has violated those laws, and so this court would certainly have jurisdiction to hear those citations. I believe there are two of them. One is registration. The other one is failure to maintain financial responsibility.
Court has reviewed the written motion to dismiss, has heard the summary from the defendant, Mr. Haynes, response from
I object, Your Honor.
I'm sorry, sir, what did you say?
I said I object.
To what, sir?
Because there's no city, state, or government that should make a rule or law that abridges my right to the freedoms and the privileges of the continent or the land of the United States. I'm a natural born man.
Okay.
And
I have
a constitutional right to be.
Sir, I've heard the objection. Your objection is overruled. All right. Your motion to dismiss is denied at this time. The allegation in the citation which you signed states that you committed 2 violations in a location that is within the territorial limits of the city of Dalworthington Gardens.
Do you have the actual ticket?
Sir, you need to be quiet and listen. Within Tarrant County, within the state of Texas, that establishes subject matter jurisdiction for this court to hear this matter. The court has not made any ruling in regards to guilt or innocence at this time. However, that does give the court authority to hear this case. Therefore, your motion to dismiss is denied at this time. Now,
do you have the actual ticket, ma'am, that I mailed back in?
I don't know if you mailed it back in or not, but I have the copy that you received notice at the time and that you signed it. And that is all that is required.
I signed it under duress as well.
All right, sir. Are you ready to proceed to trial tonight on your cases?
Proceed to trial tonight?
Yes, sir. This is the contest docket. You've indicated you wish to represent yourself, and you are facing the 2 charges of expired registration.
I need to have a trial by jury, ma'am. Everything.
Okay, well, we're going to get to there. So to the charge of expired registration, how do you wish to plead, sir? Guilty, no contest, or not guilty?
I'll make no plea, ma'am. I'm not pleading. I do not accept your jurisdiction.
Well, that's the step to getting set for a jury trial, is if you're going to plead not guilty. Are you pleading not guilty and requesting a jury trial?
There's no plea that I'm making.
Therefore, the court will enter a plea of not guilty for you. And you've indicated you wish to have a jury trial. Is that correct, sir?
The jury trial, yes.
Okay, so enter a plea of not guilty, setting you for a jury trial. So we're going to set you for a pretrial docket. And that will be September 3rd at 7 p.m. You will get a written pretrial order. You need to read it over. It explains what you need to do and the timing. If you have any motions that you want the court to hear as far as discovery or anything of that matter, they needs to be filed at least 14 days before the pretrial hearing. If you have any evidence you wish to be able to present to the jury, you need to have that marked and filed with the court according to the pretrial order. Once we have the hearing on September 3rd, you will be scheduled for a jury trial, which we have during the day. So make sure that when you come on September 3rd, you're aware of your schedule and any conflicts that you might have for September and October. You will get a written pretrial order and you'll get a reset notice. We'll see you back here on September 3rd at 7 p.m. You are released at this time unless you have any question regarding the scheduling, sir.
You say back here, this is going to be on a Zoom call again?
Yes, the pretrial will be on a Zoom call. Yes.
Okay, and I'll have instructions relating to all of this as well.
You'll get it all in writing. It'll be signed by me, and you should receive it early next week, if not earlier.
All right.
Okay. Just watch your email, check your spam folder, because there will be some attachments, so they might go to spam or junk if you have that. All right.
If I have any questions, I'll make sure I call your clerk.
Call, or you can send them in writing, either way. All right.
All right.
Okay, this concludes your hearing. You're released at this time. We'll see you back for your pretrial hearing September 3rd.
Yep.
Next case I have is Vincent Haynes. Vincent Haynes, can you unmute, please? I can see, there you go.
Okay. Sorry about that.
That's all right. All right, so Mr. Haynes, you have two cases set. We have expired registration and failure to maintain financial responsibility. And you have indicated that you wish to plead not guilty, and are you requesting a jury trial, sir?
I grant the court use of my name for future return on my equity. I say again, I grant the court use of my name for future return on my equity. Your Honor, I have to object because I never made a plea. You made that plea for me. I did not make a plea. If I make a plea, it is a plea for release. I need to make a plea for release.
Okay, so Mr. Haynes, that's not a plea that applies in this court. You're using civil law terms like this were a civil court, and it's not. This is a state-created criminal court, and as I went over with everyone here, you have three options to plead. You can plead guilty, you can plead no contest or not guilty, and by law, if you do not enter a plea in this court, then by law, I have to enter a plea of not guilty for you. I do appreciate you reminding me of that. That you indicated that it was, you're correct. I did enter that plea for you because you did not enter one of your three plea options. You are set tonight for a pretrial hearing. We sent you an order of pretrial hearing and the complaints back on August 12th, and I do not see that you filed any requested motions or requested jury charges or anything. I do see that you posted a cash bond for these charges on August 6th. Did you send in any motions or requests pursuant to the pretrial order that I issued back in August, sir?
I did not. I did not see that email. I was looking for those instructions, but I did not. I would like to make a motion to dismiss, and for lack of jurisdiction and lack of venue. I'm a natural born person, and I have a right to face my accuser. And you're telling me that there's a crime that's been committed. And I know that there's no crime against me traveling. Ma'am, I was traveling, and my right to travel should not be infringed upon.
So, Mr. Haynes, you filed a motion to dismiss that was heard in court on August 6th, and the state responded, and and that was, the court ruled that that was denied. Therefore, the court does find that we do have jurisdiction for this charge, and so your criminal charges, which are Class C criminal offenses, are pending here at this time. So, other than that motion to dismiss, I do not see any other motions filed. Mr. Bishop, is there anything from the state? Any motions filed from the state? You're muted, sir. I'm sorry.
No motions from the state, Your Honor.
Okay. So, Mr. Haynes, a plea of not guilty was entered on your behalf by the court because you did not enter a plea at that time. Are you wishing to change that plea to either guilty or no contest? I need you to say yes or no out loud. I'm sorry, sir.
Ma'am, I mean, I asked, for, even in the last time we had this hearing, I asked for your jurisdiction, and you're just telling me that it's a state jurisdiction matter. And I mean, I didn't understand how, I have to understand that, and I don't understand that.
Well, sir, you are charged with fair to maintain financial responsibility and displaying an expired registration. And Texas law requires that people who operate a motor vehicle in the state of Texas obtain and maintain a certain amount of financial responsibility. Oftentimes it is insurance, but there are other ways to provide it. And that they register their vehicle every year with the state. And so you are charged with violating those charges, which are Class C charges, and you received that notice in the citation.
I signed that
Well,
ticket.
sorry, I'm not done, which was issued to you, and
Okay.
you also received notice in the complaint that was sent to you on August 12th, and we can send the complaint to you again, but those are the charges, and you have received notice of that.
Okay, I'll send those charges again, but if you look at my ticket, Your Honor, I do not contract with the state. I rescind the contract pursuant to US 15.
Sir, this is not a contract, and the U.S. Code in regards to contracts does not apply to Class C misdemeanor offenses in the state of Texas. So that does not apply here.
You're conducting matters for money, and you're saying that there's a crime committed, and I just don't understand. So there are several things that I really object to. And
Okay,
like
well,
you
sir,
said,
listen, as you've heard me, because this is your second time to appear in court, you absolutely have the right to go and consult an attorney. And you may seek that attorney's advice, and you may hire someone if you wish to do so. All right, sir. But this is a Class C, these are two Class C charges. And the information in regards to that, the citation and the charges are listed on the citation that you were given a copy of, and they are listed in the complaint, and we will gladly send you another charge to that complaint, another copy of the complaint, excuse me, sir. So if we have no other pretrial motions at this time, if you do not wish to waive your right to a jury trial to have me hear your case, we need to go ahead and schedule this for a jury trial.
jury trial.
All right. So give me just a minute to look at the court's calendar. All right, Mr. Haynes and Mr. Bishop, the next available dates for jury trials would be either November 12th or November 13th. Do either of you have a known conflict to those dates at this time?
I do not.
Okay.
Your Honor, I do not. Either the 12th or the 13th of November, no.
All right, so we're going to set these for jury trial on November 13th. That's a Wednesday. I do believe that Monday is a holiday, so that will give us one additional business day beforehand. And so, Mr. Haynes, we do have our jury trials in person, so you will need to come to the court. I'm going to schedule both of you, the parties, to be here at 8:30. You will receive juror information. You will be able to conduct voir dire, which is questioning of the jury. The jury will be selected. Have any witnesses and documentation ready, because you'll have your trial that day. All witnesses and all documents, all evidence will need to be ready at that time. So let me make a notation here. So jury trial, November 13th. Parties here at 8:30 a.m. The veneer panel will be here at 9, and we'll begin the jury selection process very soon after 9 a.m. Any questions, Mr. Haynes?
Nope.
Okay, thank you very much. Watch your email. Do check your spam folder, because there will
I'll
be
have to check my
attachments.
spam. Yes, ma'am. That's
Okay.
what I have to do. I have
Okay.
to check my spam.
Okay,
That's
so
correct.
we will send you a reset notice for that setting. We'll make sure to resend the complaints. All right. If you have not received them by Monday, please call my court staff. They will resend it while they're on the phone with you to make sure you've gotten them. All right.
Yes.
Okay. All right. You're released at this time. We'll see you back here November 13th at 8:30 in the morning. Thank you.
Mhm.
All right, and now we will have the hearing on the motion for new trial. Let me get that paperwork in front of me. Mr. Haynes, if you'll please unmute. All right. So this is case numbers G 505-4601 and 02, style of the state of Texas versus Vincent Lewis Haynes. At jury trial on November 13th, the jury found the defendant guilty of both charges and assessed punishment. The defendant filed a motion for a new trial and requested a hearing. And the state has filed a response to the defendant's motion for new trial. And Mr. Haynes, you received a copy of that response, correct?
Correct.
Okay. All right. So, Mr. Haynes, this is your motion. I'll let you go ahead and summarize your argument for the court.
Can I find out if is this a court of record?
Yes, sir. We're a court of record. As I said at the start of every one of these hearings, that everything is on the record, everything is being recorded and streamed live as required by statute. And if when you had your jury trial, you were given the little pamphlet of information about how to appeal, and that's an appeal from a municipal court of record.
Okay. Okay. I am a natural born living man, and I grant the court's permission to use my name for future return of my equity. I am not a corporate entity. Do you want me to present something in particular, Your Honor?
Sir, you have filed a motion for new trial, and I'm giving you an opportunity to summarize your argument. Then the state may make their response, and then I'm going to rule. So summarize your argument for the court as to why you should receive a new trial.
Okay. I can only point to several facts. Number one, there was no one in the trial that was identified as an injured party. There's no way for me to make amends for whatever offenses the offended party would have against me. And any claims that the prosecutor may have or willed against me, I would like to know if he was doing so under the penalty of perjury. I also, basically, I am trying to make sure that the court knows that I appeared in trial only under special appearance so that I can get the facts and get any presumptions about my name and the use of my name correct.
Sir, I'm going to pause right there. You were not granted any sort of special appearance. You appeared as the defendant charged in a case.
No, ma'am, I did not.
Sir, do not interrupt me. The complaint was read to you. You entered a plea, and you were not given any sort of special appearance. And this is not information that is included in the motion for new trial that you filed. So this is not an argument that you included there as I have read it. So you need to be summarizing your argument that you in your motion for new trial that you have filed. This is your time to make your argument regarding that motion. This is not a time to raise new issues that were not.
It's not a new issue. When I told you I am a natural living person, and that even in your chambers, I did not identify with the all caps, in which you said that's only for reading purposes. And I vehemently objected, and I opposed that because I don't want the presumption to go forth. So that is a part of the motion. That is a part of why the request of a new trial is.
All right, continue with your summation.
Okay. So in order for any presumption or any assumption of me being a corporate entity where the court may see, and maybe the court may not see, that I am not a corporate entity and that I can settle and close this matter because the court should be able to identify the court's fiduciary responsibility and allow for this claim to be verified and settled on the record.
All right, is that the summary of your argument?
I mean, couple that with, like I said, there was no person in the courtroom that identified me as offending them or violating any laws.
All right, response, Mr. Bishop?
Yes, Your Honor. The defendant's motion essentially states, and I hope I'm summarizing this correctly, that he feels like his constitutional rights were violated because he did not receive due process. And I've pointed the court in my motion or my response the fact that he did receive due process. He had a jury trial. He had the right to face the officer, and incidentally, the officer is the one who would be testifying under penalties of perjury. The prosecutor did not testify. I'm not a witness. The officer would testify under penalties of perjury, and he did testify. Defendant had a right to cross-examine him. It was a jury trial in front of a 6-person jury, which is the number of jurors in a misdemeanor case, and these were Class C misdemeanors. And so the defendant would not be entitled to a 12-person jury unless he was in district court, which is not the case. These are not felonies. They would not be, these are Class C misdemeanors. And so the state would point to the fact that he had a jury trial. He had a right to cross-examine the officer. The officer testified under penalties of perjury. And the jury found the defendant guilty on both offenses. And there's been no other error identified by the defendant that would warrant this court granting him a new trial.
I object.
Sir, hang on, Mr. Haynes. Go ahead, Mr. Bishop. Have you finished? Your
That's all that I have, Your Honor.
Mr. Haynes, you have an objection. You may state your objection.
Okay, I object because he's saying that the officer is the one that is testifying. The officer is a peace officer. The officer did not testify as to me hurting him. There was no one in the courtroom that identified me as offending them. The case is not against the officer. The case is the state of Texas, and the state of Texas was not in the room. I didn't see that person in the room. But the constitutional issue is I have a right to face my accuser, and there's no accuser that was identified in the room.
All right.
Therefore, due process is a part of the guarantees under the Constitution.
All right. Thank you very much. All right. The court has read and reviewed the defendant's motion for new trial with attachments and the state's response to the defendant's motion for new trial, and has heard the argument here during this hearing. This is also the same court that presided at both the pretrial hearing and the trial. I'm noting for the record that the defendant, Mr. Vincent Lewis Haynes, was advised several times that these are criminal charges which carry criminal penalties. The defendant continues to refer to civil matters or civil approaches such as injured parties, fiduciary responsibilities, and making some sort of amends, almost as though it were a restitution. And though this is a criminal case, as the defendant was advised on multiple times during multiple court appearances, the Texas Code of Criminal Procedure, not the Texas Rules of Civil Procedure, control in a criminal court such as this. And under the Texas Code of Criminal Procedure, the defendant did receive a fair jury trial as required by the Texas Code of Criminal Procedure and the Texas rules. The defendant received a 6-person jury trial and was given the opportunity to hear the officer testify. The officer was the accusing witness. The defendant was given the right to confront the accusing witness and to cross-examine the officer. Therefore, the court is denying the defendant's motion for a new trial.
Your Honor,
Yes.
Your Honor, even now, you've never really conferred jurisdiction. You've never really established. I question the jurisdiction. I've done all I can to get you, the court, to understand that I'm a natural living person. I'm a live breathing person. I'm not an artificial person.
Mr. Haynes, I understand that every defendant that appears in this court is a natural living person. And this court has jurisdiction granted by the state of Texas and the city of Dalworthington Gardens, and that has been explained to you previously at previous appearances. And once again, we went over that in the court's chambers the morning of your trial. If you still question whether that the court has jurisdiction, you might question it, but the statutes, the state laws, and the city ordinances are very clear, and this court has jurisdiction over criminal charges alleged to have occurred within the city and the territorial limits of Dalworthington Gardens. You are charged with committing 2 Class C misdemeanors within the territorial limits of the city of Dalworthington Gardens. Therefore, this court had criminal jurisdiction over your cases. The court has denied your motion for new trial. You do have a right to appeal if you wish to appeal. You will need to file a written notice of appeal. You will need to file an appeal bond, which is double the amount of your fines and costs, and you'll be required to put down a deposit for the transcription of the record. And you may do that. You received the pamphlet earlier, which gave you some general information regarding the timelines. So you need to make sure that you follow the rules in regards to perfecting an appeal if you wish to do so. If not, you will need to pay your fines and costs.
Your Honor, can I ask the court a question? Do you have all the records from all of the proceedings that I've been involved in with the court?
The court does, yes. Yes.
Okay. Okay. I just wanted to make sure, because I submitted to the court a form of a bond and a non-negotiable money order, postal money order for $21.
You filed a $21 cash bond on August 6th.
Okay, do you still have that?
Yes.
Okay, all right, thank you.
And you may use
very
that as a down payment if you wish to use that to start making payments on your fines and costs.
I can use that, ma'am, the best way I can. I'll direct the court on how that can be used.
Well, it will either be remitted to you or applied to your fines and costs. If you pay this in full in another way, that would be remitted to you. All right, make sure that you refer to the appropriate time limits regarding a motion, any sort of appeal if you wish to do so. You have 10 days to get this paid in full.
I will file a motion to appeal, but I can also verbally tell you that I'm going to appeal. So as
you have to file a written notice of appeal advising me will not.
I will file it, but the instructions also said that I can verbally say that I can appeal as well.
You may tell the court, but you do need to file a written notice of appeal. And you must post your appeal bond to perfect the appeal. And that is double the amount of the fines and costs. All right. This concludes your hearing. You are released at this time.
Okay, let's break down his sovereign defense. The state of Texas is not a person. It does not walk into a court. It does not introduce itself. It does not shake hands, wave, or fill out a visitor's badge. When the prosecution says, "Your Honor, the state is ready," that is the state appearing, legally, officially, and completely. And as far as expired registration and no insurance, They are statutory violations. Traffic offenses do not require an injured party. They are offenses against the state, not an individual. Under Texas law, if you want to appeal a municipal court conviction, you post an appeal bond for double the amount. Not optional, not discriminatory, not personal, just statute.
Hi. Well, that's just about it. So, thanks for watching. And we'll see you again real soon.
And just a reminder, hit like, subscribe, share, and comment, because these are the free ways to keep the channel alive and prevent the algorithm from throwing emotional outbursts in the corner.
Actually, I wish you could see the studio floor right now. There's nowhere more fascinating after a show. Everyone's so busy. Like bees or white Anglo-Saxon Protestants.
And a massive thank you to every single one of our channel members. If you want shoutouts, emojis, early access, join the channel members. We'd love to have you. All you have to do is click join right next to subscribe or the link in the description.
There's electricians all rolling up their cables. Whoops! Sorry, guys. And there's the sound technicians unplugging all the microphones. Okay if I keep mine on for a minute, Nobby? Stand up.
The Haynes appeal shows the same pattern we see over and over again. Sovereign citizens don't lose because the system is corrupt. They lose because their understanding of the law is not law. The state does not need to be a person. Jurisdiction doesn't depend on your personal approval. And Texas doesn't need to formally introduce itself before issuing a fine. Until next time, be safe, and I'll see you soon.
And of course, there's lots of the producer's friends, all excited, waiting to meet the stars and generally getting in everybody's way. Just like our producer. Oh, we don't mind. Oh, and not forgetting the prop guys. They're busy striking the set. That's an interesting little point there. Striking. That's a word we all use in the biz for dismantling the set. Taking it apart, unscrewing things, releasing safety catches, that sort of thing.